You've heard of ChatGPT. You've probably used it. But what you probably haven't heard is how this one AI tool triggered a global patent gold rush. In fact, since ChatGPT's public release, patent filings for generative AI have skyrocketed worldwide. And if your business is using AI in any form, you're already in this patent race, whether you realize it or not. Today, I'm breaking down how ChatGPT-driven patents are shaping the next tech wave, and how you can protect your ideas before someone else does. Let's start with the facts. According to the World Intellectual Property Organization, patent families for generative AI exploded from just 733 in 2014 to over 14,000 in 2023. And filings at the US Patent and Trademark Office show the same story, a surge in generative AI-related inventions. ChatGPT made AI mainstream. Every company suddenly wanted their own generative system, plugin, or prompt-based automation. And that meant a rush to lock in intellectual property. Now here's where this hits home. Patents used to be for inventors working in labs or in garages. Chemicals, engines, hardware, or improved household products. Not anymore. Today, software and AI are the new frontier of patent value. For business leaders, patents are currency. They create defensibility. They increase valuation. And in AI, where models evolve daily, your IP can be what separates a real company from a fast follower. But before you run off to file something, let's clear up the legal ground. The US Patent Office has made it clear, only humans can be listed as inventors. If an AI, like ChatGPT, creates an invention entirely on its own, then it's not patentable. But if you, the human, guide the process, define the problem, and make inventive decisions to adjust the results, that can be patentable subject matter. And remember, every patent must meet the same standards: novelty, non-obviousness, and enablement. So document your contribution. Note what you built, modified, or architected using AI tools. That detail matters. With generative AI patent filings rising faster than ever, there's massive opportunity if you move strategically. Early filers are defining entire markets, from AI-driven content generation to autonomous software agents. But there's also risk. With this flood of applications, examiners are tightening their standards. You need precision in what you describe, how you claim it, and why it's novel. Here are the biggest mistakes I see leaders making right now. 1. Launching before filing. They go public, demo the product, perhaps publish a blog, and accidentally trigger a public disclosure. In some countries, that's an instant loss of rights. 2. Assuming AI did the innovation. Patent offices don't protect what ChatGPT spits out. They protect your human innovation. 3. Ignoring international filings. Your competitor in Germany or Singapore may file first and lock you out of key international markets. In short, skipping IP is the fastest way to lose your competitive edge. Here's my 3-step strategy to protect and profit from AI innovations. Step 1. Audit. Identify where AI touches your business. What's new? What's technically unique? Capture that in an invention disclosure document before you publish or launch. Step 2. Align. Define what's worth protecting. Are you patenting the model, the workflow, the training process? File early. Even a provisional can give you a timestamp that can save you later. Step 3. Leverage. Once filed, use your patents as business assets for investor confidence, licensing, or acquisition value. IP isn't paperwork, it's leverage. Here's a quick example. Company A built a ChatGPT-based workflow app. They launched fast, no patent. Within months, 5 clones appeared. Same features, same UI. When Company A tried to file their patent later, it was too late. It was already public. Company B did it differently. They filed early, claimed their integration method, and raised capital because they owned defensible IP. One took off, one got erased. The difference? The strategy. Let's keep this grounded. AI can assist your invention, but it can't be your inventor. The US allows a 12-month grace period after public disclosure, but Europe and many other regions do not. Once your idea is public overseas, it's gone. And patent filings are expensive, but the right ones can multiply business value on exit and during funding rounds. Always consult a qualified patent attorney before filing. This video is for strategy and education, not legal advice. If you're embedding ChatGPT or any kind of generative AI into your business, pause before you scale. Protect what you're building. To really understand how to do that, grab a copy of my book, The ABA Consumer Guide to Obtaining a Patent. It walks you through the entire patent process in plain English so that you can make smart, strategic moves. And if you're ready to take the next step, Book a call with me and let's talk about how to safeguard your innovation.